Welcome. We will let everyone get logged in and then we'll start in about 2 minutes. One more minute and then we'll get started. Okay, I think we'll get started. Good afternoon and welcome. My name is Sonia DeLuca and I'm your Associate Director and COO. I hope this finds you all staying healthy and safe and being healthy and safe out there in the vineyards. Today is the first of a series of growing season webinars that we will host for you. After our last survey that we did to the membership, the wine grape market and navigating the challenges that this pandemic is going to have on our industry ranked #1. So this is the first in a handful of webinars that we will host for you. Today's session is going to be on contracting and negotiation strategies. Next week, you can look for the second series, which will be on the wine grape market, the state of the industry, and tools for navigating grape sales for the 2020 season. I'm also thrilled to announce that tomorrow we will launch the new and improved Napa Valley Wine Grape Market. So look for details on that, on how to post and sell fruit in the Grower Bulletin email newsletter coming out tomorrow morning. Before we get started today, I just wanted to go through some housekeeping tips for today's session. We are recording this webinar, so we will send you all the recording tomorrow as soon as we get it from Zoom. You're all muted, so the way to ask questions is to use the Q&A box on the bottom of your screen. The chat feature, which is circled there in green, are for technical issues. The presenters cannot see that box, so if you have questions, make sure you use the Q&A. If you have technical assistance, type it into the chat button and we will try to help you get back on the call. Scott and Fred, who are our speakers today, will answer questions throughout the webinar. If you're experiencing any fuzzy or distorted audio, you can call into the webinar by using the phone number and webinar ID that you see on the screen and that was also included in your confirmation email. At the end, we'll send a survey link. It'll open in your browser in SurveyMonkey. It would be great to take a couple of minutes to provide us with additional topics that you would like us to cover in this series. So without further ado, I would love to introduce Fred Crombie and Scott Greenward-Meinert from Koblitz, Patch and Duffy. Thank you both for being here today and for sharing your expertise with us on contracts and negotiation strategies. I will let you two take it away.
I think I unmuted. Did I unmute?
There you go. I'll give it to you guys.
My name is Scott Greenwood-Meinert. I am a partner at Koblitz, Patch, Duffy and Bass in our Napa Wine Country office. And presenting with me today is a litigation partner and friend of mine, Fred Crombie, who is helping out in the Napa office with a few litigation matters as they come up, and has recently been involved with us in a couple of great purchase agreement issues. So he's got some very recent relevant kind of model for today's conversation. The growers contract that they have. And we're going to be presenting and throwing that up onto the screen. Fred's going to handle that for me because I'm competent at technology. And without really further ado, I'd like to jump in by saying right off the bat, there it is. One model contract, great purchase that I have seen over the years, just a myriad of different versions of this thing, from everything from a handshake to 1 page to 65 pages with technical data on the grape quality and grapes to be produced that looks a lot like a science class that I did in college. So I'm going to step in and answer.
I'm going to jump in here. Your audio is a little garbled.
Fine.
I'm not sure if we can.
Is that better?
That's a little better, yes.
Okay, I'll get a little closer, I guess. Okay. So if you have questions based on whatever your particular great purchase agreement is, we'll understand. We just have to have a baseline from which to start. With that, let's jump right in with section 104 of the model agreement. And too wide.
We are sorry, Scott, it's Sonia again. We're unable to hear you. I'm wondering if you could sign out and try to call back in or log back in.
Let's see if I can go without being on video. Would that help?
Possibly. Let's try it.
All right.
No, you're still garbled.
Okay. Then hold on. I'll just get audio. There we go.
Scott, you would just send a link to call in. If you can call, then we'll hear your voice.
Can you take over for?
Yeah. So I'll start with section 6.01, which is the force majeure provision. And we can come back to the term of the agreement when Scott is back online here. So section 6.01 of this template contract is the force majeure provision for the grape purchase agreement, and is, in as of today, is sort of the activity, the area where we're seeing the most activity from winery clients that are looking to get out of grape purchase agreements. And it's likely to continue to be the sort of area of most activity. So looking at the specific force majeure provision that's in this contract, the first thing that stands out about it is that is the description of the event. So you'll see here in the first sort of clause of the section, the force majeure provision, it comes into play where you have an event that interrupts or interferes with the business of either the grower or the winery. And the interference has to be to an extent that makes it unreasonable or impossible to perform that party's obligations under the agreement. So that is, in terms of the first step, that's the first thing you have to look for, is whether the winery that is looking to invoke this force majeure provision, whether its business is interrupted or interfered with to an extent where it has really become unreasonable or impossible to perform the agreement. But the important part here is that's really only the first step. You move to the to the next clause, what it says is that the party affected by that event may at its option cancel the agreement with respect to any undelivered grapes which are affected by the event. So this part here is really the key part of the force majeure provision as it operates today. And fortunately for growers, what it means is that the force majeure event has to not only interrupt or interfere with the winery's business, but it also has to affect the grapes. And so here I would, I'd make the argument that the force majeure provision does not apply to the COVID-19 pandemic, at least yet, because the grapes remain unaffected by the pandemic itself. They continue to be cultivated in progress. There's no noticeable effect. Any effect that you're likely to see would really come around harvest time and really would be an impact to the grower in its ability to actually harvest grapes with a workforce that is observing social distancing guidelines. And even then, the guidelines themselves wouldn't seem to be very problematic in terms of harvest. So the position that I would take with respect to this particular force majeure clause, again, is the pandemic does not affect the grapes, and so therefore it is not an event that qualifies as a force majeure event that would give rise to a right to termination. Now, every force majeure provision and agreement is going to be slightly different, so you need to actually read your force majeure provision closely, determine whether or not the event is one that just has to impact the parties to the agreement, or whether it is an event that has to impact the grapes themselves. So that's really the key there. The second part of this force majeure you'll find in the last sentence here. So it says, if such an event occurs in only 1 year and this agreement is canceled, such cancellation shall be for that year only and not affect subsequent years. So even if the winery client could invoke this force majeure provision on the basis of the COVID-19 outbreak, it is really not a basis to terminate the entire agreement, but really at its best, just a basis on which to cancel a single year's purchase. I've seen this phrased in other ways too, where you have grape purchase agreements that will require the winery client, or whichever party is invoking the force majeure clause, to take reasonable efforts to resume performance under the agreement as soon as reasonably possible. So again, what you want to do is look at the particular force majeure provision in your agreement and look to see whether it really is a basis to terminate the entire agreement, or whether it is simply a basis to avoid performance for that particular growing season.
Fred, can you tell I'm back?
Yes, I can see that
Great.
you're back.
Okay.
So really, again, with these force majeure provisions, what you're going to want to do, like I said, you want to press, if you have a winery that is looking to invoke this provision, you want to press them for actual evidence of an interruption or interference with their business, and make a determination as to whether or not that interference renders their performance unreasonable or impossible. But again, your best argument probably is going to be that the grapes in the field remain completely unaffected by the pandemic itself. So Scott, welcome back. Do you want to take section 1.4?
Sure.
1.04. Okay.
Yeah, 1.04. So what you're really looking at is what's the term of the agreement? And what Fred just pointed out about force majeure, and the last sentence of the force majeure clause in the model contract is quite relevant to what the term of the agreement actually is, which in the model contract, you see two alternatives. One is for a period of years. One is an annual auto-renewed contract, or what we call an evergreen contract. And if you're dealing with one that is, say, a 5-year agreement, then obviously that last sentence of the force majeure clause is particularly beneficial for you as a grower, because the overall contract may not be terminated. It may just be stalled performance-wise for 1 year. In the other alternative, where you're looking at an automatic auto renewal, this starts to get a little bit more into the weeds with regards to when was notice provided, with regards to whether they're seeking a force majeure suspension of the contract, or what is it exactly that they're trying to do, terminate the contract or terminate 1 year. One of the keys with this is, if somebody's going to provide notice, if the winery's going to provide notice that they're terminating the agreement or they're suspending the agreement for 1 year, did they follow the notice provisions properly? You will note in here that it talks about written notice to terminate the automatic renewal provision needs to be given no later than March 1st of any crop year. So if they wanted to do something like that, you're also arguing about, you didn't give me notice in time to just automatically terminate the auto renewal. You're then into an automatically renewed term. Now force majeure may or may not be applicable, and Fred can, argue force majeure applies to the grapes. The other part of that is notice given in a way that is provided for by the contract. And this particular notice provision in this alternative in 104 speaks directly to such notice needs to be given by registered mail, return receipt requested at the address. Well, did they do that or not? Sending an email doesn't comply with this. Giving you a telephone call doesn't comply with this. Just putting any other way other than by registered mail, it starts to sound a lot like lawyers talking about weasel terms in an agreement, but it's very applicable if you're trying to defend yourself from what may be a bogus attempt to terminate the agreement for force majeure. There's also a section later on in the contract, section 6.05. We don't need to scan all the way back to that, but in many instances, that's a very standard looking notice provision, which may apply other ways of delivery, like email or personal delivery.
Yeah, and Scott, I'll scroll down to that really quick so that they can see it. But it is an important provision because it applies anytime that you're receiving notice under this agreement, including notice that a party is going to invoke the force majeure provision. They would need to comply with this notice section.
Right. So again, a telephone call doesn't work in this situation. Anything more informal, you need to look at this stuff very carefully, because the potential here is for a legal fight, and compliance with the contract is going to become an issue, probably more than just whether the force majeure clause is applicable or not. Fred, you already talked about force majeure provisions, correct?
I did. We do have a couple of questions on them. So first question is asking us to address fires and smoke with regards to force majeure provisions. So why don't I scroll back up to that.
Did we lose Fred?
I believe we lost Fred briefly.
Okay. Well, going back to the question was, I'm reading this off of my phone. So we're looking at the force majeure, and do fires or smoke apply? If you look at the model contract, section 6.01, and unfortunately I don't have it up on my phone, it actually says including but without limitation. which is, means pretty much just about anything. So fire is definitely listed. I have certainly seen smoke-related issues used as a means. There's Fred.
Yeah, I'm not sure what happened there.
So, Fred, I was just saying that the question was about smoke and fire, and clearly fire is going to be something that a force majeure clause is going to be triggered by. Smoke is a little bit harder to say, because what you're dealing with smoke is, does it or does it not affect harvest, the timing of the harvest, the grape quality, and then obviously smoke taint is one of those issues that we are all as an industry still trying to figure out exactly how to address and when to address it in the process, because oftentimes smoke taint doesn't come up until after the grapes have actually been delivered and juiced. And at that point, people are doing testing, and they can do testing for months and months on end after that. So smoke is a little bit more difficult to deal with than fire. Fire, I think, is particularly applicable to force majeure.
Okay, and then we had one other question. 1 second, I'm trying to pull it up. Okay, so the next question was, if COVID kills the winery's demand, the question is certainly that applies. And so there I would argue that the answer is no. Although COVID-19 has resulted in stay-in-place orders that have essentially closed tasting rooms and otherwise adversely impacted wineries' abilities to sell product, that affects really the product that's already in bottle, at least in the immediate case. But again, you don't have the grapes themselves that are now the subject of this growing season and the future obligation to purchase, as of yet remain unaffected by the pandemic. They are, like I said, they are sort of in the process of being cultivated. The virus itself is not known to reside in or otherwise affect grapes. And so, my argument would be, although the winery's business may have been interrupted severely, the grapes themselves remain unaffected. And so the COVID-19 event really only meets the first of a two-pronged test for a force majeure event under this particular force majeure clause. But again, if you have a different clause that does not specifically contain language that is similar to what appears here, which really ties the obligation to cancel to grapes that are affected by the event, then you may have a slightly different calculus there.
I would also add on that depending on obviously what white grapes, red grapes, the production process can be, over 3 years before, red wine would be, in a bottle and subject to sale. Although certainly there are instances where if you were using some kind of different, less direct contract with a wholesaler, that maybe you'd be in a different circumstance. But the other part of that is I've talked to a number of and while they miss their tasting rooms and they miss that particular aspect of their business, there are a lot of instances where the wineries right now are doing quite well with online or club sales, significant upticks for some of them. So it's really a kind of a case-by-case basis on that.
Right. Yeah. And so if you have a force majeure clause that really is sort of the one-step analysis of whether or not a party's business has been sufficiently interrupted or interfered with, you still want to press that winery that's attempting to cancel the agreement. You want to press them for evidence that interruption or interference has actually made it unreasonable or impossible to purchase the crop of grapes.
We have another question that's in the chat box that I can read along to you guys, if that's okay. It says, if a winery has to close because of widespread infection at the time of harvest, would force majeure apply then? Nobody would be available to process the grapes.
So that is an excellent question, because now you do have potentially, you could have a winery that might have an argument that the grapes have been affected because they cannot be crushed and processed. So that's a more difficult calculus under this particular force majeure clause. But again, in that particular instance, you'll want to focus again on timing of the notice, when that notice is given, and in particular whether and when title passes to those grapes under your agreement. Scott, what do you think?
No, I think it's a great question, and hopefully we don't have to cross that bridge. But I do think that's going to be very contract specific. It's likely to be a problem, and it's going to lead people to have to potentially look at, other avenues. Okay, we have to pivot quickly because we've got grapes that are, ready to be harvested or being harvested, and we've got to pivot off of that winery because we've got to do what, Fred? Mitigate the damages?
Exactly. So in that case, I mean, you'll want to be paying close attention to that at or around the time of harvest, if not well before then. How the infection is spreading, what's likely to happen in terms of stay at home or other types of orders being issued by Napa County or Sonoma County, and how those orders might impact your client's abilities to process harvested grapes, and start thinking about where else you can go with those grapes in the event you do have a winery client that is shut down by a COVID-19 outbreak.
Okay, this is Sonia again. I have a couple more questions. For participants, if you could put your questions in the Q&A box instead of the chat box, that would be helpful so the speakers can see them. But I can read a couple here for you if you guys have time to take a few more.
Go ahead.
The first is, how do you suggest including a pricing increase in contracts based on the Grape Crush Report percentage increase, CPI percentage increase, flat percentage increase, question mark?
Okay, so Sonia, you get to do the difficult part here. Can you table that question until the end of the presentation? And we'll get back to that one.
Yes, you haven't gotten there yet. Perfect.
Right.
So I do see another question that popped up in the Q&A, which is, how does crop insurance come into play in these circumstances? So Scott, I don't know if you want to take a first crack at that, or you want me to do it?
Well, no, let me take a shot, Fred. Another really good question. Right now, I don't think crop insurance is going to be much help to folks because there isn't a crop yet. I think as we head into the fall, it could potentially become an issue. What I have heard already, you've seen restaurants and hotels and other businesses try to apply their business interruption insurance to this situation with, I don't think they've had any success yet, but they've headed to court. And I think, Fred, you know more about that than I do. But with regards to this kind of a pandemic and the regulations that come down as a result of that, it's really going to be in the weeds as to what is actually in the crop insurance. And I think I had a note to bring this up. If they're insurance brokers, because it could very well be you that you're going to come up. That's going to come up.
No, I would agree. I mean, I think that's a very good question. I think this is the time where you should be looking at your policy, but really how that policy comes into play in the context of this particular pandemic is really going to turn on the very specific terms of your policy. And there really is not any sort of easy and general, any sort of really easy general answer that we can provide at this point in time. But it's really going to depend on terms of the policy and how events were to play out at the time of harvest.
Let me put it another way. 25 years of practicing law, we are in a brand new place here for everybody. And what the next 6 months look like there's so much guesswork going into this right now. Some of it we're just going to find out on the other end. And whether or not this is going to be covered by insurance, not only for the grape industry, but a great deal of other industries, is a really open question that people need to start delving into now so that they're prepared when the time comes.
Okay. So lots of questions on the force majeure provision still. So one question, anything you can do in advance with respect to the force majeure provision? And I'm not sure that there really is. I mean, again, it's really the force majeure provision, I would argue, is not really, at least as it's drafted in this form agreement, is not really in play yet because you do not have an event that is affecting the grapes. But again, and then the flip side of that is whether or not the other party to the contract, whether that party's business has been interrupted or interfered with. And I'm not sure that there's much you can do in advance to prevent interruption or interference with your contracting party's business. But again, one thing that's always a good thing is to take, this is the opportune time to go back over your grape purchase agreements in detail and to understand what provisions could come into play in each one of those agreements and how they're worded. Let's see. So we have one question here. What can be done about a winery that has a contractual obligation to take grapes, but is warning that they may not have the financial means to pay for the crop? And this is one we'll probably touch on a little bit later. But again, if you have, so the financial ability to pay is not itself a force majeure event. So in a circumstance where you have a winery that is telling you that they are unable to pay or likely will be unable to pay for the grapes that are under contract, then really what you're facing is a possible anticipatory breach. So you would want to request adequate assurance from that winery that they do have the financial ability to pay. If that assurance is not forthcoming, and if they communicate that they are not taking those grapes, then what you want to do is take steps to mitigate the damages that would come from their breach of a grape purchase agreement. And that can come in a number of different forms. But the most immediate one is to find a new buyer for those grapes. And then what you would have, assuming the new buyer purchases the grapes at the same price as the existing winery client, then you fully mitigated your damages. But if those grapes are sold at a lower price, then you would have a breach of contract claim against that winery client for the difference between the contract price and the price you eventually sold those grapes for. Okay, so it looks like we can probably move to the next part here, Scott, which was we were going to identify a few provisions in this form agreement that are areas where a winery client might focus in an effort to either make the grower's life difficult or to at least avoid full performance of the grape purchase agreement. So we'll go through these one by one. The first.
Fred, let me interject. I know there's
Sure.
one question in the queue with regards to negotiating strategies for new contracts. And I think that what we're about to go over with regards to the next few sections would be and are the critical negotiating points other than price and term that people need to think about when going out to negotiate a new contract. Because these are the details these are really the details of the relationship between the grower and the winery. And the more detail, the better, frankly, for the grower, because there's less ambiguity in performance. And with that.
Okay, with that, we'll go to section 2.01, which is viticultural practices. All right. And so here, what this section is describing is the process by which the grower will cultivate the grapes and the cooperation between the winery and the grower in terms of establishing the manner in which that cultivation will take place. And so if you are a winery client that is looking to make life difficult for a grower or looking for ways to increase the likelihood that you will not have to take delivery of a full crop of grapes, you could have a winery that requests practices that are not reasonably, that are not possible or not reasonably possible in light of the grower's vineyard equipment or personnel. And here, where you have a winery that is making unreasonable requests, what you want to focus on in this particular agreement, again, is that those standards are supposed to be the product of a mutual agreement. So you are not required to simply follow every single standard that the winery sets under this section. It really is by mutual agreement. And then the grower may reject proposed practices that the grower in its sole discretion determines are not practicable and not economically reasonable. So again, there are really good provisions in here that would allow the grower to push back on a winery client that is making unreasonable demands. Scott, I don't know if you wanted to add anything on 2.01.
I would go back and reiterate that there are so many different versions of what the grower and the winery agree to are viticultural practices. This agreement calls out an Exhibit C that could be a waterfall or catalog, if you will, of additional viticultural and farming practices, do's and don'ts. Like, the grapes will be grown biodynamically, so on and so forth. All of that kind of thing can go in there. And I think the grower really needs to remember to be proactive in dealing with the winery every season into how these things are going. Do these things need to be modified after every year to try to optimize what's going on? And frankly, keep the winery from imposing things that are economically unreasonable, because that does come up frequently.
Okay. The next section was 2.03 grape quality. And so here's references in Exhibit A that sets out the standards by which the grapes are to be measured. The winery, at its discretion, may reject grapes that do not meet those minimum standards. And then 2.04, which follows, sets forth the process where you have a disagreement as to whether or not grapes were properly rejected. So there, under this section 2.04, if you have a winery that rejects grapes and the grower does not agree with that rejection, then the grapes go to an independent third-party inspector. And in this particular agreement, the parties agree that the Grape Inspection Service of the California Department of Food and Agriculture is such an independent third-party inspector. So once that inspection takes place, the inspector findings are conclusive and binding on both parties. So again, if you have a winery client that you expect is looking to avoid full performance, focusing in on grape quality standards is a likely area for that winery client. So you want to be prepared to meet those grape quality challenges head on, and think about who your inspector or your inspection service is likely to be, and how best to quickly get in contact with that service and get an inspection to take place almost immediately. Scott?
I would add in that, again, this starts to get into the chemistry of winemaking and grape growing. And either the simpler you can get or the fully the other way, which gets, incredibly chemical. Either way is preferable to some kind of middle road where I think the winery has a better opportunity to play around. Things like percentages on rot and material other than grapes, right? Some of this stuff is dependent on who's picking the grapes and who's harvesting the grapes. But I could see a winery playing around with mogs or rot or something like that as a means of trying to create controversy here.
The next section here is harvest and delivery section 2.02. This is probably the least likely of the three areas we're going to highlight for a winery client to make life difficult, but it still remains, I suppose, possible. And so one thing to highlight in this particular form agreement in section 2.02 is that it makes the winery at least initially responsible to haul the grapes away. However, where a winery is subject either to a manpower or an equipment shortage, it does provide that the grower will assist in hauling. So if you do have a COVID-19 outbreak, it is possible that the winery could remain operational, but it could have a manpower or equipment shortage as it relates to hauling. And the key thing to keep in mind here is the risk of loss provisions. So under risk of loss here, risk of loss transfers to the winery once those grapes leave the grower's control. But where the grapes are hauled by the owner, where the grapes are hauled by the grower or representative for the grower, title to and risk of loss of those grapes do not pass until they arrive at the crush pad of the winery's facility and are accepted. So again, just another thing to keep in mind as harvest approaches, you want to stay on your winery clients to make sure that they have in place adequate manpower and adequate equipment to haul those grapes away so that the risk of loss actually passes from the grower to the winery as early in the process as possible. Scott?
No, you got that one, Fred. Nothing to add.
So the next thing that we were going to go over was just what to do if you end up in a gray area where you have a winery client that has terminated the agreement or sought to terminate the agreement, and you, the grower, push back and do not agree that the agreement or that the winery client has a right to terminate, or that the agreement has been effectively terminated. So you can end up in this gray area where you, as the grower, are continuing to perform, and the winery is acting as if it has terminated the agreement. So the first place to look, again, in this agreement is the dispute resolution provisions. And that's section 5.01. So that provides that in the event of a dispute, the first step is that the parties must make a good faith effort to settle that dispute before heading to the next step. And that is, what is a good faith effort is going to really depend on the facts and circumstances of your case. But at a minimum, it does require some effort to informally resolve the dispute, either directly between the grower and the winery, or between their counsel before proceeding to litigation. So if the parties are unable to reach a settlement of that dispute, at that point, under this particular agreement again, what the parties may do is they can submit their dispute for binding arbitration to AAA in Napa County. The prevailing party in that arbitration is entitled to recover its reasonable attorney's fees. And so that is really the primary means by which any dispute under this particular form of agreement is going to be resolved. But these provisions take all sorts of different forms. So you really want to take a look at your agreement, familiarize yourself with the dispute resolution provisions. Again, it could require an early mediation, some informal effort to settle, usually coupled with a particular venue in which the dispute will take place. Here it's AAA. It could be another service referred to as JAMS, which is a mediation and arbitration service. It could be Superior Court in Napa County. It really is going to depend upon the specific terms of your agreement. And then in terms of, actually as a dispute resolution mechanism, obviously arbitration, litigation in Superior Court, it's costly. And so it could be that arbitration is out, the risk of an arbitration, whether you prevail or not, is outweighed by the attorney or arbitrator fees you're likely to incur. But that's the sort of risk-benefit analysis you're going to want to keep in mind as you proceed through the dispute resolution steps that are spelled out in your agreement, which is, how much am I going to be required to outlay for attorneys and arbitrators versus how much am I likely to recover if I prevail on the dispute. And one other thing to keep in mind is that in this particular case, an expedited arbitration may be possible under AAA rules, where you have a dispute that really gels early on in the growing season, can be resolved on an expedited basis so that both parties know their obligations going into harvest. So pause here and take some Q&A.
Yeah, Fred, I've got a question I'd like to read.
Sure.
And it goes back to something that it jogged my memory. So, when the CDFA inspection service when has CDFA inspection service been used successfully? When I tried to use it in 2017 regarding smoke taint, they were nowhere to be found. Expecting them to show up quickly seems unrealistic. I couldn't agree more. It can be very problematic. They tend to spend a lot more time in the Central Valley, it seems. and that is a problematic provision with any grape purchase agreement when you are relying on a third-party inspector with a very perishable, delicate, expensive commodity. There are really no good direct answers to that particular problem.
Sure. And one other thing to keep in mind too is the agreement. You know, it states that the the department inspector is a qualified independent inspector. It doesn't limit the inspection to the department though. So you could go out and find the parties could mutually agree on an independent third-party inspector other than the department. Right.
There was another question related to is the form contract that we're modeling today balanced or grower or winery favorable? And I certainly think in looking at it that it was intended to be pretty balanced. It's certainly not overly winery friendly, but it could easily be improved to be more grower friendly. And Mr. Wolf, I'm out of Pinot Noir.
Okay. So the next part that we touched on a little bit earlier, but the question is, you know, if you're not going to proceed to arbitration, how do you handle the winery client that has improperly sought to terminate the agreement? And again, so there, and like I said, we touched on it earlier, the grower is going to have a duty to mitigate damages that flow from the winery's breach of contract. And so you're going to want to take reasonable efforts to minimize the amount of damage. That could require you, well, some best practices to follow would be to notify the winery that you are treating its termination as an anticipatory breach of contract, and that you're going to take reasonable steps in your own discretion to minimize your damages. That would include finding an alternative buyer for those grapes. If you're unable to find an alternative buyer, then you want to evaluate the the least damaging path forward. And so that means evaluating really how you're going to grow the grapes, and then what the best option for those grapes at harvest really is. And once you've taken those steps, again, the delta, the difference between what you were entitled to under this particular agreement and then what you received upon sale or other disposition of those grapes is really going to fix your measure of damages for breach of contract. And sort of unfortunately, I think at that point, you're sort of back where you began, which is the risk-benefit analysis of whether or not you're going to pursue litigation or arbitration with that winery client to recover those damages.
I would add that it seems to me that the most important part of this dispute resolution process has to be getting out to a good start early with regards to defending yourself in carefully thought out letters or other communications with the winery to try to head this off by being thoughtful and trying to preserve the relationship as a whole, making sure you have your goals in mind as to what you want to achieve. Do you want to keep the client or the winery long term? Is there a longer term to the agreement than just an auto renew every year? All of that stuff plays into this because we're also facing, I think what we can probably anticipate to be a third straight year of a grape glut to some degree. And that's going to put downward pressure on pricing as it is. So, what are your goals overall with regards to this winery? And then what are your short-term goals in terms of, what do you do about the winery trying to get out of the contract? So.
One quick housekeeping being, Scott, your finger is over your camera.
Ah,
There we
Sorry.
go. Thank you.
I'm not used to holding the camera this long. Sorry about that. So,
And so then, Scott, it looks like we've got a few minutes left here. Well, let's see, we had another question pop up right here. In the event the contract is unable to resolve a winery default and they stonewall, what is the likely time frame and cost of legal resolution? So it depends really, again, on the terms of your agreement. An arbitration generally, although not always, is going to proceed faster than litigation in superior court. The flip side of that is that it is more expensive because in superior court, you are not paying for the judge's time, but you are paying an arbitrator, usually in upfront daily fee with additional hourly fees on top of that. So the more involved your arbitration is, the more costly it can become in terms of arbitrator fees. And then in terms of sort of estimating the cost of litigation in terms of your attorney's fees, what it's really, it is impossible to give a reliable estimate. It's going to depend on the hourly rates that your attorneys are charging. It's going to depend on how aggressive they are in investigating and pursuing your case. It's also going to depend to a great degree on your attorney and the other side's attorney ability to litigate the matter efficiently, which means really focusing on the issues that matter, attempting to informally resolve disputes as they arise, and avoiding sort of unnecessary motion practice, which can really drive up litigation expenses. All of that said, litigation is almost always expensive. So, one thing you'll want to keep in mind is if you find yourself heading in that direction with a winery client, you do want to get some sort of reliable budget from your attorney so that you can make that cost-benefit analysis of whether it is worthwhile to pursue litigation against the winery client, and if so, when it makes sense to negotiate a settlement.
I also think this subject ties off rather well with the idea of what do you do when somebody is, not paying or hasn't paid for the grapes, which heads directly into every grower has a producer's lien under California law, Food and Ag Code sections. There's section 3.02 of the model contract actually lays that out rather well. It is particularly good, frankly, that the Grape Purchase Agreement model has this provision in there. It also has a very good explanation of what the statutory lien is below the provision. And I would add that there are kind of two ways that you can proceed with a producer's lien when you're not getting paid. And one of them is what Fred just discussed a little bit, which is going to court. And I'll let Fred elaborate on that, what that would look like in this context in just a second. But the other way is to go to the Food and Ag Department of the state government and go through their growers lien process. And I have had a couple of clients go that route in the past with mixed results. Anybody who's impatient about getting their money probably ought not go to the state government for help because they can take a very long time. On the other hand, they carry a giant hammer in their bag, and that is the Food and Ag Division can go ahead and suspend or terminate a winery's alcohol beverage licensing. as a means of helping procure your money at the other end. That's a big hammer, and I've actually seen it used successfully. But again, it is a time-consuming process, to say the least.
Yeah, and then in terms of proceeding to court on the producer's lien, the benefit there, I think, is that you're going to be in control of your case. So it's your litigation, you're in control of it. You can get a fairly early remedy in terms of an injunction that would prevent the disposition of the wines that are crafted from your grapes, and potentially permit the sale of those wines with the resulting proceeds being subject to that injunction. So, in terms of strong arming a winery client, if you are able to get into court and you are able to get that early injunction, that could lead to an early resolution with the winery. But that is going to be probably, in terms of attorney's fees, the more expensive route to file litigation and to have your attorneys draft all the briefing that is necessary to get that early injunction. So it's the downside, it's the cost versus the earlier resolution of your lien claim. Let's see. And then Scott, I think we had one question which we held over, I think, to the end here.
Right.
So I don't know if you want to tackle that.
Pricing. Yeah.
Yes.
And I don't know what I just did, but my screen just disappeared. I hope it didn't. Okay. I'll read the question if I can get to it. There it is. How do you suggest including a price increase in contracts based on grape crush report percentage increase, CPI increase, flat percentage increase? Well, they all work to one degree or another. CPI increase, you do not see a great deal in a grape purchase agreement. You do see some flat percentage increases in contracts, say 2%. It is quite common. What is also quite common is a one or the other, depending on which one is more provision. These tend to be very long clauses, and that's just a drafter's problem, because how do you deal with a formula that addresses the annual grape purchase, or excuse me, the annual crush report, and then a percentage based off of that, versus if that's more than 2%, then you go with the higher, or 2% covers it. I've seen that frequently, and I like that kind of clause because it creates a floor for the grower. Whereas if, say, you look at, say, 2017, 2016 prices for grapes versus 2019 prices for grapes, we're going to see a downturn here, and you want to avoid going backwards where you can in your contract. So that kind of a 2% annual increase is something that I try to put in most of my clients' contracts as a minimum increase. And I think that's all. The rest of it, come see me.
Yeah. So that does cover, I think, the ground we wanted to cover with this form agreement. I think the key really is to remember, we're using this agreement to highlight some of the issues that you're going to see, but how those issues actually play out and what their resolution is really going to depend on the specific wording of your agreement.
And, Fred, there's one more question that we didn't get to that came in yesterday that I wanted to address quickly.
Okay.
And this feels like a perfect question now. What should you do if you have contracted fruit from 2019 and have not been paid? When do you get a lawyer involved? And now is about when you're already a little late doing that. But it does go to what your relationship is with that particular winery that isn't paying, and what do you know about them. But yeah, I would say right about now is a good time to go talk to a lawyer.
Yes. You want to make sure that you still have a product that your lien can be enforced against. You know, the longer you wait, the less likely it is that product is still there. I do not see any further questions. So I think that wraps it up as far as our agenda, unless I missed something, Scott.
Well, I think we're at an hour now. I do feel like there was one question related to negotiating new contracts and strategies related to that. We've gone long. Maybe we need to come back, Sonia, and do that one separately.
We can do that. Thank you both so much for your expertise today, and thanks to all of our attendees for bearing with our technical challenges. These webinars are, you know, we're at the whim of the World Wide Web and the Wi-Fi signal. So thank you all so much for attending. Thank you both, Fred and Scott, for sharing your knowledge and expertise. We will be sending the recording out along with the sample grape contract template that we reviewed today, just as a guideline and guidance for all of our members. So any other questions that you have that we can provide and we can bring to you in an educational format, please send those our way, and stay safe and healthy out there. Thanks again.
Thank you, everyone.
Thank you.